Hi, everyone. As he said, I'm Loree Kovach. I'm with Epiq. We're a global legal services provider, but my division in particular works in the claims administration space. In the US, Epiq has handled really large cases, including the interchange matter that was mentioned previously. And then here in Europe, we're handling several of the claims before the CAT, including, as well as Mr. Merrick's claim, and doing some other work internationally as well. We have a great panel here to talk about consumer protection. I have Matthew Angelus here to my right. He's a senior associate at Torys LLP in Canada, where his practice focuses on all matters related to consumer protection. He represents clients in a wide range of class actions, ranging from claims for refunds for flights canceled as a result of the COVID-19 pandemic to allegations regarding the chicken content of fast food sandwiches. He also maintains an active regulatory compliance practice, advising companies with issues such as advertising, cost of borrowing, loyalty programs, and language requirements for doing business in Quebec. Next, I have Dr. Vikram Kumar, who you might have seen in an earlier panel today. He's a principal at Cornerstone Research in London. He's an antitrust economist with close to 10 years experience advising clients in antitrust and competition products liability and life science matters. Vikram leads teams to support clients and testifying experts in all stages of litigation and regulatory matters. He's currently advising clients in multiple collective action matters in front of the CAT and in other European jurisdictions. He's also advising a large tech company on private regulatory matters in Europe. In the past, he's worked on matters in front of the UK's Financial Conduct Authority, the European Commission, the Competition Commission in South Africa, and several US courts. And then I have Drew Hathaway, who's a partner at Milberg. He's been instrumental in Milberg's expansion into Europe and works daily to achieve access to justice worldwide. Drew has extensive experience in both opt-out and opt-in procedures in different European countries and the nuances associated with them, including experience with claim foundations, book building, third-party financing, and claims administration. As a US-trained class action attorney, Drew uses his skills and knowledge of the American system to advance the collective redress market in Europe and beyond. So our topic is consumer protection. We're going to pose a few questions to the panel and hear from each panelist for their thoughts with respect to the particular jurisdictions within which they work. To start out with, I was talking to a colleague of mine about a conference he attended in the US where various members of US government agencies spoke about how they rely on the plaintiff's bar to enforce some of the regulations that they're responsible for, right? They don't have the resources to do so with respect to every bad actor themselves. And so I think that starts us out at a good spot. So for the panel, I'd like to hear from each of you on whether you think consumer protection class actions serve a regulatory or a quasi-regulatory purpose. Drew, we start with you. Yeah,
sure. In my mind, there's no question that civil litigation does serve a quasi-regulatory purpose. What I've noticed from my experience in the US and in Europe is that in the civil code jurisdictions, you don't have as robust discovery. And so what I see happening is that the regulators will act first, and then litigation follows behind because the regulators have built up all the evidence, and then that makes it a lot easier to pursue the cases. The problem is, and I think this really came to light with the Dieselgate scandals, which is what really started the discussion in the EU, was what happens, what do we do when the regulators don't act? And sometimes the regulators don't act because they don't have a big enough shtick to change the behavior. And sometimes regulators don't act because of politics or economics. It's tough to go after the biggest industry in your country. And so the only alternative to regulators is giving people access to justice to bring litigation. In my personal practice, I've seen it time and time again where civil litigation serves a regulatory purpose. I had a class action in the US. It was against an adult care facility that specialized in taking care of people with dementia and Alzheimer's. And they were grossly understaffing their facilities in North Carolina. They had 3. And so we couldn't craft the claim as a medical malpractice claim because then you wouldn't be able to get class certification. So we brought the case as a breach of contract action, saying you were required to provide this minimum number of hours for people, and you're not doing it. And the result was these very vulnerable people were literally being left in their own filth until their flesh rubbed off. They weren't being bathed for a month on end. Their fingernails were overgrown by 4 centimeters with fecal matter under it, and it's because these companies weren't staffing appropriately. So we filed a lawsuit and immediately got an injunction from the court, which is the judicial branch, regulating the executive branch because they weren't doing their job. And what was interesting is overnight, not only did this defendant begin staffing their facilities appropriately in North Carolina, but they had 110 facilities across the country, and they began staffing them appropriately everywhere. And what we found was, they were getting penalized maybe 40,000 euros a year for this behavior, but it cost 200,000 to staff it the way that they were contracting to and were supposed to do. We ultimately ended up not getting class certification on that case after 6 years of hard litigation. And so in one sense, we weren't successful because we didn't monetize the case, but that really wasn't what it was about. We had already won the case by changing the behavior of this company that was taking advantage of incredibly vulnerable people. And so, when the regulators aren't doing their job, what's the alternative? And the answer is, you need to give people an opportunity to have their rights heard and adjudicated.
Yeah. No, I think that's a really great example. Another one I find interesting in the U.S. is the SEC. So you'll often see carry-on claims brought after there's been a private securities action, and it tends to make the SEC's efforts lower, right? The proof is already there, the class is already identified, you can take the people who have valid claims from the private action and move them right on over into that fair fund. So it's another way to sort of make it more efficient for the government to act. So Vikram, do you have thoughts on that?
Yeah, absolutely. I think litigation can certainly be, at least in my view, a reasonable complement to regulation. There's new evidence that's actually come out now that, at least in the US, when you look at medical devices and you compare those that are protected from tort litigation and those that are not protected from tort litigation, there's much few safety issues with those that are actually subject to litigation than those that are not. And this has been empirically demonstrated. And so you can clearly see evidence that in some instances, litigation does change firms' behavior, and with good reason. There's the deterrence aspect, and then there's also the fact that, once someone's being found guilty, they want to, change their reputation or whatever it is to do better. So there's no question about it.
Yeah. And the deterrence aspect to it plays out in different roles. It can play out through the class action sphere, but just the threat of a class action can impact how a company acts, whether it's in the regulatory space when they're adapting their products and their services. They can say, hey, what is likely to be the biggest class action threat? And often those questions relate to, in the consumer space, to things like fees. But it also affects the valuation of a company in a transaction space, whereas previously, and obviously one still does, look at the different valuation markets, look at the different trends. But as part of any transactional due diligence, we're going to see a regulatory sphere and what is the class action risk relating to certain policies, procedures, and fees. And that's something that 5-10 years ago we never would have seen. And so in that regard, just the threat makes people a lot more, or in companies specifically, a lot more in tune to those issues. There is a danger, however, where the regulator might have an interest in taking a soft approach. For example, I can think of a securities regulator acting in a specific sphere where there was a product that didn't prejudice the customer, the consumer in any way, but it was one that didn't quite fit in line with securities legislation as it was drafted. And the regulator, in this case it was the AMF, which is Quebec's security regulator, wanted to encourage everybody in the field to change, but without coming down too hard on them. But it became a challenge to actually change that behavior, because the second that it would be changed on a group level, it would be sending a signal to class counsel that there would be something there. And that's especially relevant, and we'll talk about it a little bit later, in a jurisdiction like Quebec, where there's an absolute liability or an absolute presumption of damages in certain circumstances.
Thank you. So I think that kind of leads us into another topic pretty easily. Do consumer protection class actions encourage frivolous litigation?
Yeah, it's a good question, and I think it's one that's very relevant, and I think that the U.S. Chamber of Commerce has done a really good job of sort of setting the narrative here in Europe about the Americans are coming, they're bringing frivolous lawsuits, it's going to ruin your judicial system. But the truth is, these cases are really expensive to bring. Like in the U.S. practice, we don't use third-party funding, so we are not getting paid for our time until the very end of the case. and then we're funding all the disbursement costs, all the experts ourselves. And so, these cases can go on for north of 5 years if you're dealing with appeals. And so we have tremendous incentive to only bring cases that we think are valuable, because otherwise it's a complete loss for us. It makes no sense to file a lawsuit that doesn't have a meritorious claim to it. Part of the way we do that, and this has been touched on in previous discussions, is I can't emphasize enough the importance of expert evidence. I've been fortunate in my practice in the U.S. that it's always been expert-driven, and so that's a part of my practice. But anytime I'm thinking about bringing a pan-European case in multiple countries, I'm going to make sure that I've got the best evidence in the world and that the defendant is already dead to rights on liability before we file it. And so I think that there's market reasons why you wouldn't want to bring frivolous lawsuits. It's a ton of time. It's a ton of money. Nobody wants to waste time or money on a lawsuit that's not worthwhile. And in fact, I learned the hard way in the U.S. of not pushing my experts towards an opinion because they never really defend their opinion well unless you get their true and honest opinion. And so, as a baby lawyer, I learned that lesson the hard way. And now, when I talk to experts, I don't guide them in any way whatsoever. And I let them know, look, I'm paying for your time. I'm not paying for your opinion. And if this isn't a good case, I need to know that because I don't want to waste everybody's time and money pursuing it if it's not a meritorious case. Also, in the U.S. and in every jurisdiction I've been in, there's a court approval process to these settlements. So it's not like you can just run off and take advantage of consumers. I think this is another one of kind of these talking points from the Chamber of Commerce. The attorneys are the ones that are only benefiting, but ultimately, there's a judge who's going to make a decision whether or not, have you done your job for these clients? And are you justifying your fee based upon the good that you've done for these clients and correcting this defendant's behavior? And that's really important that the courts take a look at that. And, I know there's a lot of debate right now, academic debate and policy debate in the EU about, what do we want this to look like? What is third-party funding going to look like? Do we want opt-in? Do we want opt-out? How high do we want the threshold for class certification to be? There's plenty of room for debate about all of those issues. But the fundamental question that each member state needs to ask themselves are we going to be a culture that allows defendants to act with impunity and do whatever they want to do in situations where regulators either can't or won't do anything about it? Or are we going to be a society that allows people access to justice to even have the right to go and prove their case? And that's a fundamental question to ask, and it's one that I personally feel quite passionate about because when you have the ability to change corporate behavior through the legal system, through the justice system, that's a heavy responsibility, and it shouldn't be taken lightly. And cases shouldn't just be pursued because they're going to make money. Cases should be pursued because they're the right thing to do. I know that my firm is currently pursuing some environmental claims here in Europe, and we're going to be bringing these claims on behalf of people that have been harmed by companies polluting others. And it's not a case that we're going to make money on, but it's a case we're going to do because it's the right thing to do. And if people don't stand up against this behavior and if people don't have access to justice, then you're helpless, and that's not a good place to be.
I think Drew makes a very good point. In terms of access to justice, a lot of the consumer protection class actions are dealing with small amounts of money. We're talking about fees that might be in the range of $5, $10, $15, and these are cases that never would be brought but for the existence of a consumer protection class action mechanism, and that's especially true in an opt-out jurisdiction. There was a panelist yesterday, I think it was John Yanchunas, who mentioned a number of frivolous cases which come into effect usually brought by very inexperienced class counsel who are trying to emulate their successful colleagues. He gave two examples which I think are quite striking, being the short fill for the Starbucks cup and the 11-inch Subway sandwich. We have some examples as well that I've seen being mailbox placement by the post office, things that come up that might not necessarily be the most judicious use of the court's time. I come from the Canadian province of Quebec, which is not only the only French-speaking jurisdiction in Canada, it's also its only civil law jurisdiction in the continental style, which contrasts quite significantly with the rest of the continent. And there are 4 rules with regard to our consumer protection regime. First of all, there's no class action waiver, no class arbitration waiver, no forum selection, and no choice of law. All of this results in a very strict consumer protection regime, which has a lot of benefits, but combined with a low bar for authorization or certification, you do see some inexperienced counsel take actions that maybe they shouldn't take. In Quebec, you have the ability to sue not just on behalf of a number of consumers as part of a class, but to sue a number of defendants in a single industry, even though there's only one plaintiff who has one cause of action against one of those defendants. And so we see single practitioner shops taking actions against 25 defendants at a time within a single industry, for example, the 25 largest banks and financial institutions. These actions are settlement-driven because there's no way that that firm can prosecute the claim against all 25 banks. And I have one specific firm in mind that has 40 or so actions like this on the go. The consumer is not benefited through those actions because anything that's negotiated would be far less than what they might deserve in a well-founded case. But the justice system is also not served because there's no way that these cases can be brought forward in a judicious and time-efficient way.
Well, and I think another thing, topic that never comes up as much as it should when we're listening to these cautionary tales from the Chamber of Commerce and others, are the adverse costs provisions that exist in the UK and then in some European jurisdictions as well. I think that also is a barrier to frivolous litigation when it's present. So, Vikram, do you have anything, commentary on that?
Maybe the only thing I'd add to what Drew and Matthew said was, look, I mean, at the end of the day, everyone's making a business decision, right? Firms, on their part, have got, their reputation to deal with. They have their customers to deal with. It would be strange to say that, firms that really fight hard to win business would, at the end of the day, jeopardize that position by, exploiting them. It may happen in really bad cases like the ones that you mentioned. Those may be really bad actors, but we need to be careful in terms of, saying that, kind of painting the picture that, there's some exploitation going on at every stage. So that would be my only.
And I respectfully disagree with my colleague that adverse costs is something that's going to prevent frivolous lawsuits. I think that there's already enough risk involved without adverse costs that, the cases that I've pursued and we are pursuing in London, we don't even think about having to buy ATE policies when we're considering cases. We're like, is this a meritorious case? Is it not? And if the decision is to move forward, then you just pay the several $1 million to an insurance company. It's an insurance company racket at the end of the day. And that's really what it is. But I don't necessarily think that you need to have that in order for there to be better case selection. And that kind of brings me to another point. A lot of my colleagues in Europe have misconceptions about contingency fees. Mm-hmm. I can't think of a better way for attorneys to have their interests aligned with their clients than not getting paid by the hour forever, regardless of the outcome, right? When your interests are perfectly aligned with your clients on a contingency fee basis, you want to get the case done efficiently and you want to get it done well because your interests are aligned with your clients. Whereas if you're getting paid by the hour and the outcome doesn't necessarily matter, well, why not litigate for 12 years? And how well does that serve your clients at the end of the day? It serves the lawyers well, but it doesn't necessarily serve the clients well. And one other thing about the frivolous litigation is, these corporations that we sue are some of the most powerful and wealthy entities on the planet. And they have an unlimited bankroll for litigation. And they hire the best of the best lawyers. There's no doubt about it. I'll be the first to admit it. Everywhere I've seen these defense lawyers from the US across Europe, they're superb. And so we're already starting in a position of a huge disadvantage. No plaintiff's outfit, whether it's funded by third parties or others, has the bankroll of these companies. And so it's important, I think, to give people that opportunity, to give them access just to get to the answer. You might lose at the end of the day, but at least give people the opportunity. And again, I think that the costs of it all and the time of it all is a tremendous, tremendous filter to get rid of frivolous litigation.
Yeah. So Matthew mentioned this and briefly, but I want to hear from the panel on the low Barda certification or authorization in some of these jurisdictions. Does that afford better protection for consumers? Matthew, you want to start?
Sure. We heard a lot yesterday about the US-style model towards certification, where it might take several years to get to a certification decision, where the amount, the cost, and the resources that are put into the certification process far exceed the steps that will follow. This is not the case at all in Canada, and this is certainly not the case in Quebec, where we call it the authorization process is considered really just a filtration mechanism. Our authorization process generally takes 6 months to a year, and the plaintiff just needs to meet 4 conditions which are met, which are treated very liberally: the existence of common questions, the existence of a color of right, the existence of a class of people, and that the representative is an adequate representative. Our hearings last 1 day at most, unless it's a mega suit with 25 defendants or so, as I mentioned before. And the certification or the authorization bar is met in more than 70% of cases. What has that initially resulted in is a large number of suits which, once authorized or certified, take a long time to get off the ground. At first, certification or authorization led to quick settlements of claims because it was originally thought, and this may still be the case in the US model, that once you're past that step, where there's smoke, there must be some fire. Not so anymore, as more and more of the cases have been certified or authorized. There's less, the fact that the bar is so low has simply indicated, not just to defendants, but to the court and to journalists and anyone who's looking at a case, that really all they've met as a procedural hurdle, nothing's actually been proven yet. And so whereas we saw in the early stages a series of quick settlements, today we're seeing more and more cases being brought to trial, and more judgments where, after a prolonged class action, which may have lasted 5, 6, 7, 8 years, the end result is a judgment which determines that there are no damages, that ultimately the plaintiff's initial claim, which was found to meet a low color of right standard, ultimately is not a good legal claim. And this isn't good for anybody, because it isn't good for the consumers, who some may have had a different case from the class representative, who are all caught up in the same action. It's certainly not good for class counsel, who may be working on contingency and having spent 6, 7 years waiting to find out whether their case has real merit. But the biggest impact is on legal delays. And as the class action chamber has been overrun in a certain way with authorized actions, the delays just to get a procedural motion heard are getting longer and longer and longer and longer. And we might think that it can take months just to have a case managed decision on a very simple procedural matter. And I think that's the biggest impact of the low bar for authorization.
Vikram, I think you can speak to that for the UK.
No, absolutely. We've seen this in the UK as well with the low Barda certification, and we probably are going to head in that direction as well over here. The only, a couple of things I want to mention in addition to what Matt said, which is that, you know, at the end of the day, right, when economists think about consumer protection, you know, that idea comes from a belief, right, that, you know, markets fundamentally do not serve consumers in certain ways in certain conditions. And what are those? It's basically a question of information asymmetry, right, that consumers either don't know, right, what prices are out there, or they don't know about the quality of products that are actually being sold to them. It may be a misrepresentation, for instance, right? And that is fundamentally a question of lack of necessary information on the consumer's part, and that which eventually prevents them from going and seeking alternative businesses, alternative suppliers for their products. So when you lower the bar drastically or have no bar at all, it's not really clear that it's actually solving that problem in the first place, right, relative to a situation where you actually have a higher bar, right? So I think, you know, while it is true that it may force earlier settlement, it may force settlements, or, you know, firms may not want to go into a protracted legal battle and then just be done with it and provide some kind of justice to consumers, it's not really clear it's actually solving that fundamental problem of lowering the bar is solving the fundamental problem of whether consumers are able to access the information that they need.
Well, in the UK also, you have sort of two different mechanisms with very different standards, right? You have the representative actions, which are pretty hard to meet, and then you have the CAT claims, which are getting certified now very, very quickly.
Yeah, no, exactly. And the interesting bit there's a tension in that with representative actions, the Supreme Court after Lloyd versus Google basically said that, you know, that procedure is not going to be applicable in a situation where individual class members, you know, the harm that they've suffered is not uniform. On the other hand, in the CAT procedures, you know, the broad axe principle applies, aggregate damages are okay, right? And consumers, even though it's set to be compensatory, it's not really compensatory at the individual level, but it's in the aggregate. So there's a fundamental, like, inconsistency between how the representative action has gone, the route has gone, versus how
I don't think there's any way to answer this question or to get this issue perfect.
Right.
Yeah.
And so, I mean, really what we're talking about are policy decisions that need to be made by the member states on what do they want their systems to look like. You know, in the U.S., in the criminal context, we have a very, very high burden of proof, beyond a reasonable doubt. And that's because, as a matter of public policy, we would rather guilty people go free than innocent people go to jail. And so in the context of class certification, I think that each member state needs to make a decision. Do we want to err on the side of giving people access to justice or not? You know, I think that the U.S. threshold is robust. I don't think it's easy to get class certification in the U.S., and there's an enormous amount of case law on it. Portugal doesn't have a class certification process at all. They also don't have res judicata for the members because they don't even do notice. And so I'm 100% confident we're going to do good for consumers in Portugal. Go to the UK with the representative action, and Mr. Merrick's is a hero. I was really neat to hear him speak yesterday. You know, but that's our common law, you know, father, mother is the United Kingdom. And they've had the ability to bring representative actions. I think it goes back to the mid-1800s. And the fact that Merrick's is the very first one, and it still hasn't been resolved, tells you that the system is not working. If people don't have access to justice, then, again, the defendants are going to operate with impunity. And sometimes it's not an 11-inch sub. Sometimes it's diesel companies polluting the environment that we all share. And you know, like, and that scandal, for example, it's nitrous oxide is the main pollutant, which causes smog and acid rain. Smog is one of the leading causes of COPD, which leads to 500,000 Europeans dying sooner than they should have. And so some of these actions have tremendous implications on society, and it's not just monetary to the consumer, that's just an added part of the claim. And so really, at the end of the day, I'm not competent to tell the member states of the EU how they should do it. I just think that the member states of the EU need to decide what they want. And if you're going to err, which side are you going to err on? And that's really what the debate's about, because it's impossible to get it perfect, and perfection is the enemy of progress. And I always say it's better to make a mistake and correct it than to make no decision at all. Because that's a decision in and of itself, and it's the worst possible decision that you can make. So if things aren't working, change it. That's the beauty of the system. You can refine it, and you can make it better. And you can take the parts that are working in the US or the UK or in Portugal and incorporate what makes sense and fits within the cultural sensitivities and the judicial sensitivities of the state that you're in.
Right, and I think sometimes public opinion can also be a really big driver of this. I mean, if you look at the diesel cases, I think they might have been the catalyst for a lot of the changes we've seen.
100%.
Some of the public discourse, right? You're seeing people in particular jurisdictions getting full reimbursement for these cars, and then other jurisdictions that have no mechanism for that, and I think that can be a driver of change as well.
Yeah.
So we've talked a lot about the costs of bringing class actions, and so I think this is a good time to talk about the public funding option. I'm going to start with Matthew for that, since I think Quebec has the public funding option already. And I don't know how familiar the group is with that, so if you want to start out by just sort of explaining what it is, and then we can go from there.
Sure. So Quebec was the first Canadian jurisdiction to introduce class actions, and it did so in 1979, or a couple of years after the introduction of the Consumer Protection Act. And so those two regimes were meant to function together. And to get the class action regime off the ground was introduced at the same time a publicly funded class action funding system. We call it the FARC, where litigants, specifically their counsel, can apply for funding for legal fees, for costs, for disbursements, and ultimately the result of an adverse judgment. In our case, costs will only be a couple of $1,000s of court fees. We're not talking about a full loser pay system. But it does provide funding from the beginning to the end of the process, even though it's at a relatively moderate level, because the plaintiff's counsel can still does work on contingency and will still collect on contingency in the event of a successful judgment. The publicly funded regime today is funded largely through the undistributed amounts, either in a settlement or as a result of a judgment, but the undistributed amounts, and that is basically set up along a percentage line of the higher the amount of the undistributed funds, the lower the percentage that is remitted to the public access fund, but these amounts can be quite significant, and it can go up to 90% in some cases of the undistributed funds. The process itself, the existence of the publicly funded class action regime does in some ways act as a gatekeeper for claims, because the plaintiff's bar, one of the first steps in a litigation, and often before a class action is even filed, the first step will be to apply to the fund for a degree of funding to get through the authorization process. And that may be accepted or refused. It's usually accepted, but in the cases where it's refused, the plaintiff has the opportunity to go and appeal before an administrative tribunal the refusal to fund the claim. And so it acts as a first gatekeeper. Again, bar is relatively low, but it does ensure that claimants, regardless of their ability to seek a large class, and therefore may have less large incentive at the end, can actually have their day in court. With this said, there's still a place for private litigation funding in Quebec. There's a debate as to whether it's along the some European countries, for example, Ireland, that would consider it champerty. That debate is still unresolved, but there's still definitely a market and an active place for private litigation funding, notwithstanding the public model.
Can I ask how big the private funding market is?
It's not enormous. It would be a small number of cases that are funded through private models, and in relatively rare cases. I don't have an exact figure, and that's okay. But the vast majority of cases still are plaintiff counsel funded insofar as they are done on contingency, but with the fund providing a sort of a baseline compensation.
And is there any sort of analysis or public record of what types of cases are getting funded through the FARC? I'm going to be really interested to see if it really is litigation that's furthering a public interest.
It's almost all consumer litigation. There was some, around 5 or 6 years ago, there was a quick trend or a quick jump in relation to actions relating to sexual assault. But as many of those went through the authorization process and didn't quite get past that hurdle, the fund, which had initially said yes to funding those claims, is now backed away.
Gotcha. I know this is being considered in some European jurisdictions. Drew, do you have some thoughts on that?
I can't speak to that with precision, but I do know that there are discussions on the EU level about potentially some public funding sources. And honestly, Matthew, until we had started talking, I didn't know that that was even a thing in Canada, and I think it's a fantastic idea. In the U.S., we don't have that, obviously, but we do have cypres, which John was mentioning yesterday. Cypre is when you take some or all of the common fund that's left and you give it to a charity. We do a lot of that at our firm in the U.S., and it does a lot of good. Pro bono is also very important as well. I think in the U.S., plaintiffs' lawyers tend to be a little bit more on the left side of the political spectrum. So we like representing the David versus the Goliath, and we like pursuing cases because they're the right thing to do, not necessarily because they're going to make money. Obviously, it's a business and you need to make money, but that doesn't have to be all the cases that you're doing. And so I know in the U.S. we do a bit of a mix, but perhaps something like this in Europe is a great idea, certainly for the cases that fall through the cracks and don't get, third-party litigation funding. Because at the end of the day, it's about access to justice. And if people aren't getting their day in court because it doesn't monetize, then that's a problem that needs to be addressed.
Yeah, no, absolutely. So I think we've talked a lot about a lot of different jurisdictions, so I'd like to pose the question to the panel. What do you think the future for multi-jurisdictional consumer class actions looks like? Whoever wants to start.
I'll jump right in. There's been discussion today about the importance of cooperation with one another. I can't echo that sentiment enough. We were already talking about what an uphill battle it is for the plaintiff's attorneys versus these incredibly powerful defense, multinational corporations that are hiring, the best white shoe defense firms internationally. And so the only way you can have a fighting chance in litigation is by collectively getting together on the plaintiff side, working cooperatively. What we found in the U.S. is that it leads to quicker and better resolution for our clients when the lawyers aren't fighting amongst themselves. And it's this saying, I'm from North Carolina, and we've got some funny sayings from the South, but one of the sayings that comes to mind is, pigs get fat and hogs get slaughtered. Do you know? If you're going to be a hog and a greedy and want all the money and not want to share, then you're going to get slaughtered because 100% of zero is nothing. And it's much better to work cooperatively with one another, not be greedy, and then that way you focus your attention on the defendants. The best position for a defendant to be in is to create infighting amongst the claimants, because then it's a huge distraction. You're not focused on them. And then the discussion becomes about, oh, look at all these greedy attorneys, as opposed to, hey, we've just polluted the entire world, lied to every single regulator about it, and we're killing people. And so it's super important to work cooperatively with one another. So the way I see it going forward is there's going to be tremendous international cooperation. It's been the privilege of my career to work with European attorneys. It's really opened my eyes to seeing things a lot of different ways. And there's a lot to be gained both ways from a cooperative relationship with one another. And so I see the way this progressing is multiple states should be bringing the same claims at the same time against the defendant. Because the way, it's counterintuitive, but the way you solve a problem is you make it bigger. That's how you get attention. That's how you get the case resolved. Because if they can just defend it forever and that cost doesn't hurt them, they'll just do that. And so you make the problem bigger by bringing it on multiple different fronts, and then you can get redress for consumers on a uniform basis, and it gives the defendant something that's very valuable too. They can buy their piece, and they can do it in a very efficient manner. I know in the US, when we resolve cases early on, the defendant's gonna get a discount. They're gonna pay less because there's a time value to money, you're getting the case resolved sooner, you're getting certainty, and you're buying your piece. And so, you know, when I see litigation in the EU going on for a decade or more, that's concerning because that doesn't benefit the claimants ever. That only benefits the defendants, and it shouldn't be this way.
No, and I think there is a benefit and perhaps even an appetite for more multi-jurisdictional cooperation, not just among the plaintiff's bar, for example, but even by having a case heard with regard to the law in many jurisdictions in a single venue. For both the plaintiffs and the defendants, there's interest in getting a firm resolution of the judgment. And we've seen an introduction of, at least in the Canadian internal market, even though we have 10 different jurisdictions within that market, of what we call the multi-jurisdictional case protocol, which requires judges faced with 2 or 3 claims in multiple provinces to speak and coordinate on procedural matters so that one decision can carry the way. But we can see that appetite among not just within several jurisdictions within a single country, but several jurisdictions within different nations. And there's no real impediment to that other than the international recognition of judgments. As long as you can have a qualified court make a qualified decision, there's no reason why those judgments couldn't be executed, and not just in the jurisdiction where they were rendered, but elsewhere as well, as long as there's a proper recognition for that process. And there may be an appetite for that going forward.
When do you think the cross-border directive is going to facilitate that further, potentially?
That's a whole nother, you're talking about the directive that's coming into place at the end of this year?
Yeah.
It's going to be interesting to see how that plays out. I know that the Chamber had tremendous influence on that as well. There's tremendous shortcomings to the directive. It is helpful that, you know, if a foundation has standing in country A, you can bring suits in country B, but, you know, until you have an opt-out regime, there's still going to be a huge category of cases that will never see the light of day. Right. And that's a problem because, again, you can act with impunity.
But to your point, though, to the that perfect is the enemy of good, there's no reason why that couldn't be a first step to eventually going towards a full opt-out regime across many jurisdictions, as opposed to some where you have others that remain opt-in, or for example in the UK where you sort of have both.
Yeah.
So I think that kind of covers most of the questions we wanted to go over, and we've got a few minutes left, so any closing thoughts from the panel?
I'll just say that, you know, as a U.S. attorney, it's been really, really wonderful to work with lawyers from other countries and to see how things are done here. And I know from our perspective, it's not like you just come in and stamp, you know, American firm, American firm, American firm. That's the opposite of what we're trying to do. We're trying to build European offices with fantastic European lawyers who will get the benefit of our knowledge of working up cases, our knowledge of experts, our resources, our systems to make things more efficient. The goal has never been to rubber stamp American firms across Europe. It's more about augmenting what's already here and working with partners here to hopefully help people and the environment here. Europeans deserve that right. And it's something that most Americans take for granted. I know I certainly did until I came over here and started seeing the horrible things that happen to people, and there's nothing they can do. And so I appreciate the opportunity to be here, and it's a pleasure to be in Amsterdam. And this is an exciting jurisdiction in terms of pushing the envelope, and it's going to be interesting to see how things play out.
Yeah, very exciting indeed to see what the next 5 years will bring in terms of how a consumer protection regime will grow throughout the continent, and it'll be a lot of fun to see how that develops, and look forward to seeing about those developments.
Likewise. It's going to be really exciting. Thank you.
Yeah. So any questions from the group?
For your speech. It was really, really good. My name is Charlotte Pope-Williams. I'm a barrister and senior associate at Pinsent Masons. You spoke about buying your peace and access to justice as well. I'd be really interested in a panel's views about the impact of remediation and redress schemes, which are often mandated by statutes in the UK. So in financial services, the Financial Conduct Authority can say you must give consumers redress, and how those things impact the sort of consumer protection, class action space, because that could be a very effective way, one might argue, of a defendant buying their piece quickly and effectively, and for consumers to get compensation promptly without having to do a group litigation order or go through an authorization process. But I wouldn't want to do economists and are like out of business, as some people were saying yesterday.
So,
Go ahead.
So we have seen some of that. On the financial services side and the banking side, there is mandatory remediation, which has resulted in some jurisdictions of essentially the evaporation of the class action proceeding in those regards, because there's nothing left to go get. In other jurisdictions, and I apologize for harping on Quebec a few too many times today, but there is, where we have an absolute presumption of damages, the fact that there was remediation may reduce or serve to eliminate the compensatory nature of it, but there's still an envelope of, for example, punitive damages to discourage the behavior in the future. But it would take a jurisdiction that accepts the fact that remediation is not enough for that to go forward, and that's not the case everywhere.
And I can't speak exactly to the provisions in the UK that you were talking about, but I understood the question to be, is if there's statutory fees for a particular behavior, does that make the process more efficient? Was that the question?
Sorry, I don't have the microphone.
Yeah.
So it's going to project out. No, it's whereby you have a scheme where you effectively just pay across compensation to a class or a cohort of individuals. So in the UK, you've had pensions mis-selling, and so lots of pension funds are paying over compensation to individuals who have lost out, and they do that proactively, and sometimes that can be mandated by statute, or sometimes that's just sort of the party acting independently of their own volition because they don't want to end up in long-winded litigation.
I understand. I couldn't be more supportive of that, even if it means that it's less opportunity as a lawyer, because that's an efficient way to get consumers redress for whatever was done wrong. I think that's a fantastic idea, and if it lightens the load on the courts even better. We have statutory fees in the U.S. for certain behaviors. It has to be codified, but typically the defendant isn't willing to pay just because they're on the hook. You still have to litigate. And ultimately what happens is those statutory fees, you say, well, here's the maximum you're exposed to. The defendant's going to negotiate a settlement with the high end being the starting point. But I do like the idea of those type of fees because it makes the system more efficient. And most importantly, it gets the consumers the compensation that they're owed and puts more in their pocket. What could be better than more efficiency?
And I think that, sorry.
I was going to say, we've seen this work in the claims administration space. We're often contacted by big corporations that have realized that they have liability based on some sort of action. And they've done the math, and they realize that the cost of a potential class action is higher than if they were just to pay out the affected population. And so we'll do that, in a far less public manner than a public class action settlement. But we've assisted many large corporations in that kind of redress because they've made the determination that it's more effective to pay out and get ahead of any potential litigation. And the bonus they get from that is then the release from the people that they've paid, right?
Well, and a lot of defendants will do that. I mean, we'll have instances in the U.S. where you sue a defendant, say, for example, a bank is charging excess, like if you have insufficient funds, they charge you $35. Well, you make 5 charges in one day, and it's the last one that was the most expensive that put you into overdraft. Well, they were rearranging them so that the first one was the most expensive, and then they hit you with 5 overdraft fees. And these are the most vulnerable people that are banking, that are bouncing their checking account. And when those banks got caught, it was just the cost of doing business for them. They just settled at like 85% of what it was worth, and they still netted 15%, and they were happy to move on. You know, and you would never, that would never be redressed if you didn't give people the opportunity to say, hey, this isn't right, what you're doing.
Yeah. I think we have one more question.
I don't know if this is working. Hello, hello, hello. Doesn't seem to be working, I'm not sure. Is it working? Oh,
Yeah,
there we
we
go.
can hear you.
Now we can hear it. Yeah, just on the remediation scheme. Actually, I've got a few points. Remediation schemes, we as claimants lawyers have been somewhat critical of them, particularly when they're run within the company. And indeed, the courts have been critical of some of those, some of the bank ones that they've been critical of. In a way, it can turn out to be litigation on a private basis. You've still got to litigate the case within the remediation scheme. Certainly that process has been quite contentious. So I think the remediation scheme, certainly in a public sense, if the FCA introduce one, then or for financial services, then they can work very well. And of course, we've got some very famous ones, PPI, for remediation schemes. I just wanted to say, just on some of the points you've been making, Drew, is that I think the tradition within Europe is, of course, for bigger government and therefore regulators. And I think that at least in policy terms, the regulator is seen as the protector of the consumer. What I think now is being realised is the regulatory gap. And I think the development now is who's filling the regulatory gap, because the regulator simply doesn't have the resources. But we've seen, for instance, a recent decision in relation to pumping sewage into rivers in the UK, in which the court said that's not for us, that's for the regulator, so that you can't bring an action in relation to that pumping because that's a regulator matter. It's a government matter rather than a litigation matter. So I think that's developing, and I think the problem, as you've just alighted upon, is that there's a lot of misinformation comes across about the American system, and of course we all know the hot coffee argument, which the American Chamber of Commerce pumps out. And of course the American Chamber of Commerce has had quite a lot of influence on the regulatory proposals under VOS for financiers. And one of those, for instance, misinformation I'd say is that one of the things he says is that litigation funding leads to frivolous cases. Well, as a claimant lawyer, if I could persuade a funder to fund a frivolous case,
Good luck.
I'd be very happy. They're even more difficult than American lawyers. You might follow things for moral reasons, and indeed, I'd want to do funders down because they may also do so, but they're unlikely to follow a frivolous case. You talked about public fund. We've proposed, there's been a proposal in the UK for a contingent legal aid fund, CLAF is its acronym. I'm not sure we could take the Canadian acronym, but CLAF. And that's just never got off the ground. The government's just not been interested. Who's going to provide the seed funding for it, for instance? Now, it might be that the CyPro process in class actions, in the opt-out process in CAT, might provide that seed funding to the Access to Justice Foundation, but I think that's going to be somewhere down the line. We'll wait and see if that happens. Just there is one thing in Europe that we do have is the Aarhus Convention, and the Aarhus Convention is a convention that deals with environmental cases and does allow the removal of the cost-shifting obligations in environmental cases for consumers, and I think it's a convention that people don't refer to a lot, but it is. There are mechanisms there, but we've got a long way to go yet on ESG claims.
Thank you. Any other questions? Oh, got back here. Do we have time for one more question? Yeah. Okay.
It's just a remark really on the lacuna of the regulators not doing their job effectively. I think that's what's being said. They, of course, have a statutory duty in many instances to do that job, and they're open to judicial review on someone who's been harmed or who has standing to get them to do their job. So I wondered what the panel's view was that as an adjunct strategy to going ahead and suing in a class action of actually requiring the regulator to step in through a judicial review process.
It's a timely question and a good one. Yesterday in Berlin, there was a press conference with the DUH, which is an environmental nonprofit. They've been litigating with the KBA, which is the motor vehicle regulator there, to get their hands on documents. And through that litigation, it was released yesterday, a bunch of documents from Bosch, which completely implicates all the auto manufacturers knowing that they were doing something illegal. And so that's an example of somebody challenging a regulator and getting something beneficial out of it. But at the end of the day, I mean, regulators are, they're entrenched, and that's tough to go after the government, right? If they don't make a decision you disagree with, it's a tough thing to do. I think that the regulators and the civil attorneys should work hand in hand if they're trying to protect the consumers and vice versa. But what we've seen, at least in Germany, is that the KBA, while it's doing what it can on recalls and whatnot in the diesel scandal, they're doing everything that they can to protect the industry as well. And so they're sort of betwixt and between. And I get that. You're talking about going after the major auto industries that provide tons of jobs for your people, make lots of money for your people. It makes sense. But, as U.S. lawyers, I've never certainly gone into litigation trying to bankrupt a company or make people lose jobs. What you want to do is come in with a certain level of monetary compensation that changes their behavior, deters them from doing it in the future, but they can keep operating their business. And in the U.S., everybody thinks that the class action system is just destroying companies, but you do surveys, and what you find is that consumers like these companies more after they acknowledge something they've done wrong and maybe give something back to their consumers. So it actually ultimately ends up being a positive thing because you can build your relationships with consumers by doing the right thing. And look, people make mistakes. It happens all the time. But it's important to own that mistake, make amends for it, and move on.
I think regulators sometimes also split the baby. I mean, I think back to the Takata airbags. So there's a ton of settlements in the United States, all dealing with recalled airbags, and the ones where NHTSA has entered a recall settle very quickly. And then there's a whole class of airbags that have very, very similar defects, depending on who you talk to, that haven't been recalled, and settlements with respect to those are basically impossible. I think the regulator is sort of giving the perception that it's done the right action here, but have they really gone as far as they need to? And there isn't really a mechanism to challenge that.
And that's a great example of a case that, wasn't a case that was monetized, but you're talking about airbags that weren't deploying and people were dying. And so it was really important to change those out.
Yeah, they were exploding. I mean, not even not deploying, but exploding. And
exploding, yeah. So.
All right, I think we're out of time. Thanks very much to the panel. Really engaging discussion. Thank you, everyone, for participating.
Thanks.